हमारे साथ कानून और न्याय मंत्री किरण रिजिजू जी हैं. So a lot of issues have been cropping up. We in the news business, it is our job to sort of highlight some of these issues. Let's start with the latest, in which just yesterday we had a Supreme Court hearing. This is on the issue of same-sex marriage. आप हमारे दर्शकों को समझाइए कि while the government is open to same-sex relationships, and you had mentioned that in the historic Supreme Court verdict, which read down Section 377. But yesterday you had submitted an affidavit saying that you are opposed to same-sex marriage. Why is a government that is okay with same-sex relationships opposed to same-sex marriage? Why is it a matter of policy?
Thank you very much for inviting me here. This Lokmat National Conclave is a very important place, and the views which you make here will certainly go deep amongst the people. First of all, on this issue which you just raised, we are, as a government, we are not opposed to any kind of activities done by anybody as a citizen. As a citizen, as long as you follow the law of the land, you are free to do whatever you choose to do. A person of any sex can also choose to lead a particular life which is suitable to him or her. But when you talk about marriage, marriage is an institution. Marital institutions are guided by different specific laws. And I'm not going into the details of the laws, but they are guided by different provisions in different laws. When it comes to institution, it has to be regulated by certain laws. The law must be enacted by the Parliament of India, because Parliament of India reflects the will of the people. Court can definitely interpret into many things. Court can also go into certain issues which requires some clarity in terms of correct interpretation. We have no issue on that. The only issue with the government is marriage is an institution, it has a sanctity, and it must be backed by law which takes into account our traditions, our ethos, our heritage. There are so many things in our country. India is not a country which emerged suddenly. It is an ancient country with rich cultural tradition and all customary practices. So that is why our position is very clear on that.
So one of the other interpretations that has happened recently is on the appointment of Chief Election Commissioner and Election Commissioners. The court seems to be of the view that in order to maintain neutrality and impartiality, they want to ensure that there is a committee comprising Prime Minister, Leader of the Opposition, and the Chief Justice. The government reckons this is an infringement because it's an appointment, it's an executive appointment. How do you see this constitutionality of appointment versus the political nature of appointments?
First of all, you have to identify what are the issues which are administrative in nature, which are issues which are totally at the domain of judiciary. The Constitution says very clearly that for the appointment of election commissioners, it has to be done through a system, a law, which has to be enacted by the Parliament. I agree that there is no enactment of any act on that. But that is at the domain of the legislature. The matter which came up in Supreme Court is not because of some conflict or some kind of confusion. And there is no, urgent requirement also. But somebody has gone and filed as PIL, and the Supreme Court took cognizance of that, and they delivered a judgment. When the Supreme Court or any court in India pronounce a judicial judgment, I should not comment on that. If I feel that there is encroachment into the domain of legislature or the executive, I will react in appropriate forum or initiate appropriate action. But on the basis of a judgment, I am not ready to offer a quick reaction to that.
No, not just in the context of this, but even in the context of appointment of judges. This has been going on for a while now between the government and the court. Do you plan to bring any legislation which clearly demarcates when it comes to appointment of, because if the court is saying, in order to maintain neutrality, you have to have the Chief Justice on the panel to choose the Chief Election Commissioner, the government can argue the same for appointment of judges also.
On the question of neutrality, the Constitution has given certain provisions. As a member of Parliament, I will be biased towards my party. The moment I take oath as a minister, I am supposed to be neutral, because everybody is equal for a minister. Whether you are a minister or election commissioner or your person in any of the constitutional authority, you are supposed to be or expected to be neutral. If every appointment is to be done by a committee which involves the Chief Justice of India or a judge, who will perform the judicial function? We all know that the total numbers of pendency in India is rising very fast. We are almost at 5 crore 90 lakhs pendency of cases. Now people are saying that so many cases are pending in the courts. Courts are unable to deliver judgment or unable to dispose of enough numbers of cases, which is not correct actually. Courts are disposing numbers of cases, but the new coming up cases are higher in numbers. That is why the pendency rate are increasing. But just because the pendency rates are increasing, can government or the legislature say that we will take over judiciary? Because judiciary is unable to deliver the judgment or to finish off the pendency of cases, they should give up, and the legislature and the executive should take over the judicial work. It cannot happen. There is a clear-cut demarcation of responsibilities amongst the three wings in the state. If you try to breach those thin lines, then it will precipitate a situation which will lead to crisis. It can be political crisis, constitutional crisis, or some kind of resentment. So we have to be very mindful. And I must tell you another thing, that our party, led by Honorable Prime Minister Modi ji, we have utmost respect for judiciary. Independence of judiciary cannot be compromised. We have to strengthen judiciary, and we have been doing that. All this, the digitization which is going on in the Indian judiciary, all the technological supports being provided to the judiciary, during the peak of the pendency, Indian courts were still functioning. This is because under the e-courts phase 2, we have given adequate support to the Indian judiciary, and under the e-court phase 3, we have allocated 7,000 crore, which has been announced in the budget. So no government has come close to our government in terms of support provided to the judiciary. So we are very clear. Independence of judiciary also means independence of legislature and independence of executive. Independence is not for one organ. All the organs have the equal and reciprocal independence, and we must respect that.
Once an